Hey guys, today I'm going to be covering Chapter 1 from Adamson's Law for Business and Personal Use. This was a good book that was recommended online for the Business Law Objective Test FBLA competitive event. So I think this will be a good lesson and a review on Chapter 1. So we'll start with the basics of law. Law is basically the enforceable rules and the customs of society, and the important part is that they are enforceable and that there's some sort of consequence if you break them. And we have various names for laws at different stages in terms of like how they're published. So slip laws are basically the text of each individual piece of law as passed in the final form. And they're usually released like immediately after they're passed in their final language. And then usually after a session of the legislature, they will put together, whether it's the state legislature or the federal legislature, the Congress. Usually they'll put together a book called the U.S. Statutes at Large for that session. And it basically will contain the entire set of laws passed within the certain session. And then codification is when you're putting together the various laws into like an organized book that's organized based on the subject. In the U.S., that would be the United States Code, and different states have their own codes as well. And so what it does is it takes various laws that have been passed since the founding of that jurisdiction, and it will organize it based on various subjects such as property law, criminal law, and so forth, so that an individual can easily look at all the laws of certain jurisdictions instead of having to dig around for a specific act or trying to figure out like which laws exist and don't exist and so forth. Instead, codification allows you to see everything at once. And the first code of law was from the Babylonian king Hammurabi in 2000 BC. And of course, the U.S. Code is a federal code containing all the statutes passed by Congress. So there are 4 stages in the development of law. The first stage is that there basically is no law, and if you are wronged in some way, or you feel that you're wronged in some way, you have like almost total power to just take revenge. And the second stage is when, from all that violence, some group or government or individual seizes enough power, and they end up trying and reduce the violence or perhaps prevent their own overthrow. They convince the wronged people, the people who've been attacked or feel they've been attacked. They convince them to accept things of value, money, goods, whatever it may be, as compensation or payment. And then the government or so-called sovereign will basically act like a judge and decide when an award should be given and how much it should be. And then eventually courts get set up because the one individual, usually in the past this was like like a baron or a king or something like that. This one person, usually in those times there wasn't really a democratic ideal, so that individual also held not only the judicial power but the executive and the legislative power as well. So they had very many things to do, so they couldn't just sit around all day deciding low-level cases. Eventually courts get set up with somewhat professional judges initially to resolve the cases, and eventually you have the development of the law. So you have criminal laws created to deter individuals from certain wrongs ahead of time, and you also have the courts being given the power to enjoin or prevent the harmful conduct before it happens, as opposed to just giving damages after the fact. So the two main systems of broad systems of law in the world. The first is common law, which is basically a system of judge-made law, whereby precedents kind of overlap each other and step on top of each other, and so over time um, you have a variety of precedents on a variety of issues. But the most important part is that it's judge-made, and that it like different judges over time end up having this or making their decisions, and they add up over time. So it really has its historical roots in England. It's used in the United States. It's used the federal court system and all but one state court system. But civil law is based on positive law, and by positive law we mean law that is set down by either the executive or the legislative branch, the political branches. Like, act of Congress or a legislature in certain countries, or, if it's an autocratic country, just whatever the ruler says and so forth. Has its roots in ancient Rome, and it's used in the state court system of Louisiana, and the Napoleonic Code is the main code of civil law today. In civil law, there's very little judge or judicial discretion, so the codes of law are very, very dense. They're very complex. They try and cover every single situation as much as possible, try and prevent what happens in common law, which is that there are ambiguities, and then the judge has to fill in the ambiguities by kind of sort of making the law in a way. Okay, so the history of common law goes as follows. In early medieval England, even though nominally there was a king who ruled all of it, in practice they needed the king or the queen, in some cases needed the support of nobles such as barons, the feudal barons, in order to really get anything done. And so the feudal barons basically dominated the political system. They basically had close to total control over what happened in their little fiefdom. And this meant that whenever they acted as judges, because they didn't really have the idea of checks and balances or separation of powers back then. When they basically acted as judges, there would be a variety of different legal customs over different, like, extremely small plots of land, because the individual barons may not necessarily have owned like huge swaths of land. So this meant that in 1 or 2 square miles there's a certain rule in a certain case, and in a similar case just nearby, adjacent to those 1 or 2 square miles, there's a completely different rule. And so if you're traveling across the kingdom, then you will have to you have to know all of these different customs and so forth. You have to keep them in mind and make sure not to violate them, because if you don't, then you will have to pay damages. And so that it's very hard to do business in that environment. So what that means is that what ends up happening is that King Henry II, when he gets into power, he ends up basically taking away much of that power from the barons, and he puts that power into a set of nobles who he appoints as judges, and they end up riding circuit or traveling across the country to hear the cases. Basically wherever there was an indoor location, they would use as a courtroom. So a barn or cathedral, whatever it may be. And then because the king cared about the people, because if he didn't, then they would revolt he made them appoint local citizens to help them determine cases. It's basically the first forerunner of the jury system. In the winter, all of those various judges would become basically create their own little court, and they would basically be an appellate court. They review all the decisions that unhappy parties brought to them, and then so the individual judges, when they made their decisions, they look at decisions from the other courts to kind of see how similar cases were resolved. And then when a higher court, which is the court of King's or Queen's Bench, told them, had made a ruling, that would basically be binding, because in effect, because they knew that if they ruled against that, then an individual would just appeal it, and they knew they would basically win. So yeah. Okay, and then finally, common law courts end up causing too much adherence to precedent, and sometimes these precedents were like really weird sometimes, because like facts that shouldn't be that relevant, like the exact form of a document, or where a period was, or whether something was capitalized or not, ended up like deciding the case. And those courts also failed to prevent harms ahead of time. So if it was known that, I don't know, a farmer intended to let's say divert water away from another farmer, then the individual who knew that their water was going to be taken away by someone else, they would have no way to stop that other than wait until their water is taken away, and they'd have to appeal that. Alright, go to a court for that. So instead, to solve this, a court of equity is basically created, and so it would be able to compel certain actions. And initially, it was the court of just one person, the Lord Chancellor, which is a clergyman, and there still is an equivalent of a Lord Chancellor today in the UK, but it's not a judicial role anymore. There was no jury, and initially only nobles fought cases, but then commoners got access, and then they created a full court system with multiple judges and administrative secretaries and so forth. And then in the US, this kind of exists today in a way, but in the federal system and in 47 of the state court systems, there's no distinction between law and equity courts. Instead, the same courts you can sue for damages and sue for an injunction in the same court, which is not what you could do in early medieval England. But in 3 states, there's still separate courts of equity: Delaware, Mississippi, and Tennessee. Delaware and Mississippi, they're called chancery courts, and in Tennessee, they're called law equity courts. Right? I hope you enjoyed my review of Chapter 1 of Adamson's Law for Business and Personal Use.